Oftentimes, employees will, after the fact, contact employers to indicate that they feel that they were being treated in a way that was unfair or unjust or discriminatory. They make a lot of allegations, sometimes either on their own or even through counsel. You might have received, for example, as an employer in the past, something called a demand letter, and this is basically an attorney letter asking on behalf of a former employee or a current employee for some type of settlement or resolution. And in the event that the employer doesn't provide that, it does infer a lot of times, these demand letters, that a lawsuit's going to be brought. Of course, in any situation where you receive a demand letter, you should never respond without obtaining the advice of counsel. Anything that you say in a response could always be used down the road in a litigation, and you have to be very careful about how you word things and how you specifically phrase your response to any such demand letter. Sometimes it's better not to put anything in writing at all and just have a verbal discussion. Sometimes you need to lay out the facts with case law to support where you're coming from. Sometimes you may want to provide documents to the particular attorney or a complainant in that situation to show that you had justification and a legitimate business reason for taking the action that you took. And sometimes you might find yourself in a situation where you realize that maybe there is no defense, or a defense is a little gray, and you may want to try to resolve that situation up front before litigation actually commences. So obtaining the advice of an attorney in this situation is really critical, because you don't want to say anything out of turn that's going to hurt you down the road, but you also don't want to just put that letter in a file until at some point in time it ends up becoming a full-blown lawsuit.